Hello, everyone, and welcome to this, I think, the third IBL presentation for summer 2021 on big data topics. Here we're discussing big data and antitrust. So I'm really excited to introduce an expert panel on this topic. And panelists, if you don't mind joining with your video, I'd appreciate it. We're going to be handling today's discussion as kind of a conversation. I really just want an opportunity for these experts to talk about this topic and talk with each other. There'll be an opportunity for questions if anyone has them, but there's so much to say on this topic. Just understand up front if it's possible that we don't have a lot of time at the end. So why don't we do the introductions? And we can start in the order they appear on my screen anyway, with Professor Daniel Sokol. Professor Sokol is Professor of Law at the University of Southern California. Professor Sokol, maybe just by way of introduction, where are you calling in from today? And what would be a good place for people who are interested in what you have to say to find more of your work on this topic?
Thank you, Sean, for having me. It's always a pleasure, either live or virtually, to be in Iowa. I'm calling in or videoing in from sunny Southern California. And I say that because it's always sunny in Southern California. In addition to being a professor of law, I have a 1/3 teaching appointment also in our college, or rather our School of Business. And in addition to that, I'm also senior advisor to White and Case, both out of the LA and the DC offices, where I have an antitrust practice. And in that context, and also virtually in DC, I'm the academic advisor to the US Chamber of Commerce. So virtually, not only can I be in Iowa, but I can be literally across the United States and really around the world. The best place to find my work is on my website. And it's really an exciting opportunity, not just to be with you at the University of Iowa, but also this topic, I think, is one that has generated a lot of interest within the broader business community and also within the legal practitioner community, because big data is everywhere.
Fantastic. Thank you so much for joining us. Next, we have Dr. Rosa Abrantes-Metz, principal at Brattle Group. Dr. Abrantes-Metz, where are you calling in from, and where can audience members find your work?
Good afternoon, everyone. It's a pleasure to be here. Thank you for including me. I am calling in from New York, where it is also sunny. So I am, as a general background, I have had appointments as adjunct faculty at NYU for 10 years and have taught in other universities, namely I was a lecturer at the University of Chicago. But for the last 20 years, I have primarily been doing consulting, first having started at the Federal Trade Commission as a staff economist out of graduate school and then moving on to the private sector. I have specialized in collusion, manipulation, fraud cases, but over the last several years, a lot of my work has focused more significantly on modern terms. Times do so involve collusion. So a lot of my papers are available on SSRN in terms of working paper versions. I've also published on this topic at the CPI. I have testified on ongoing matters that relate to credit card payment systems, healthcare, air transportation. So these are all ongoing cases that bring to bear not just from my perspective, liability, damages, monopolization, market definition, and collusion in these contexts. So this is something that I have been thinking about a lot for the last several years. Thank you.
Fantastic. Thank you so much for joining us. And next is Professor Mikhail Gal, Professor of Law at Haifa University. Professor Gal, where are you calling in from today, and where could the audience find your work?
So, hi, Sean, and it's a pleasure to be here. I'm calling in from Israel, from Haifa, and it's actually 7 p.m. after a sunny day as well. and if students or anybody else wants to find my work in English, they can find it on my SSRN page. I've been writing about different issues regarding the digital economy for some time now. And I combine law and technology. I combine economics, technology, and law. So I've written about, for example, algorithmic consumers. I've written about access barriers to data markets. I've written about remedies designed for digital markets. And I look forward to talking about some of these issues in this panel.
Fantastic. I'm so delighted to be able to share all of your expertise on this topic. Just to set the stage, as my former students know, and as many people realize, antitrust can kind of be broken into some big buckets. So we can think of, collusion, coordination, things that would fall under Section 1, monopolization, Section 2 of the Sherman Act issues. Also, mergers and acquisitions, which fall under Clayton Act, Section 7. There's obviously more than that, but I was hoping to kind of work through those categories here. That's kind of the big scope of what I want to talk through. So those are what we're going to focus on, or what I'd like to focus on initially. But before we even get to that, Professor Sokol, I was hoping maybe you could start us off with, well, what is big data? Even if someone knows what antitrust is, what's big data and how does it interact with antitrust?
So there are general parameters to big data. So the first question is, do we call it data or data? Either pronunciation seems to work. We think of it initially as the 4 V's. The first of those V's is volume, which is really a function of the scale of the data. How much of it do we have? So we are generating data all the time. So what's different between big data and data? Simply the amount of it. Then the second of these V's is the velocity, which is how do we actually analyze all this data that's coming in? So think, for example, about a car today versus a car 10 years ago. We have a lot more data streaming in to those cars to let us know the location of the car, how every piece of the car interacts with the road, with other parts of the car. And that's just a car. We could imagine this also in terms of our cell phones and all the data that is being generated from our various apps, from our locational data, et cetera. We might also think of the variety of the data. So, data comes in different forms. So think of it again, the cell phone, right, is wireless data that's being generated. Some of the data is being generated, from our apps that is then sold to third parties. Some of it is being used in all kinds of different ways, but really there's a variety of different types of data that we're getting. Think about all the data that we get from our various websites that are shared every single month, all the tweets, all the videos that we watch, whether it's Netflix or YouTube. And the last of the V's is the veracity of the data, which is how certain are we of the data? How accurate is it? And we've seen, for example, bias in the way that we collect data. We may have data deserts. We may have all kinds of assumptions built in that don't quite work. And it turns out it's not so much the data that's the issue here, it's what we do with it. Are we really baking in certain kinds of assumptions that lead to faulty consequences in terms of our own decision making? Because ultimately, it's not data itself, it's the analytics that comes from the data that matters. So Sean, you asked, what is it that makes up big data? What I'll actually suggest is it's not just the big data, it's what you do with it. And what you do with it is going to change very much based on data availability and, frankly, your business model. And so, as is often the case in antitrust, it ultimately comes down to a case-by-case basis.
Fantastic. So that is really helpful. And it lines up with how I typically teach antitrust. Antitrust is about conduct. You always have to do something. So that's a really helpful start. Why don't we take that as our sounding board and jump from there? So Professor Gall, maybe I could move to you if you don't mind. Building on that, what are the ways that big data could affect conduct or lead to anti-competitive injury or illegal consequences in like a collusion or a Sherman Act Section 1 type setting?
Right. Sean, you've touched upon, I think, one of the most important challenges that we have with regard to the application of antitrust in the digital world. Because, and what I want to touch upon, and I'll do it quite briefly in the time allocated, I would like to touch upon algorithmic coordination and whether it comes under our current limitations. So let me start first by completely agreeing with Danny that big data by itself has no value, and its value is created when it's used to make better decisions. And this is the task of algorithms. Algorithms are computer codes which are designed to make decisions which are based on data inputs. That's why big data is so important, because this is these are the inputs for the decisions made by algorithms. And algorithms can be designed to set or to refine their own decision parameters in accordance with the data which is inputted into them. And then they are what is called, what you might call learning algorithms, because they teach themselves from the data how to make their decisions better in the long run. And so one question that arises is whether algorithms which make decisions for firms regarding, let's take the easy case, price. Okay, algorithms that set prices for different sellers, whether or not their conduct, which might amount to coordination, whether or not this infringes Section 1 of the Sherman Act. Now, I think that to understand that, first of all, I think we need to think why it is that algorithms can affect coordination among rivals and lead maybe to higher prices. So there are several features of algorithms that are important here. One of them is the speed of the collection, of organization, of analysis of the data, which enables exponentially quicker decisions and reactions. Another one is the fact that algorithm can enjoy high analytical sophistication. What it means is that it makes it easier to solve the multi-dimensional problems raised by coordination, such as establishing a jointly profitable price in a market with differentiated products. Just think about the fact that algorithms have defeated world champions, for example, in the strategic game of Go, which again is an example of the level of sophistication that they can enjoy. And then there's the fact that algorithms make rational decisions which are devoid of ego and biases. And it also potentially eases coordination by making their decisions more predictable. And one last point that I want to make here, but there are more, but I think this is the one I like best, is the fact that algorithms actually change the mode and the dynamics of communication, which is needed to reach an agreement. And this builds on the difference between algorithms and humans, because if I'm thinking something, unless you have superpowers or you're connecting me to all kinds of electrodes, which is probably in the future, you don't know what I'm thinking right now. However, with regard to algorithms, are, as John von Neumann, one of the founding figures of computer science, said, they're recipes for action. So if I show you my algorithm, you are going to know what my decision is going to be given a certain data input. And all these, together with other factors, make it easier for algorithms to coordinate. Now, there are different methods of coordination that might take place. On one end of the spectrum, firms might use algorithms to engage in traditional collusion. And one example here is the case of Topkins. What was there is that Topkins and his competitors agreed that they will coordinate prices. Okay, they will collude on prices. And then they use the algorithm in order to determine the prices. Okay, so the algorithm was actually the tool for putting in place an agreement that they agreed upon before. And this comes under the law. We have no problem with such scenarios because they're captured under our laws. I want to mention another scenario, which I think is the most challenging here. And this is where algorithms learn by themselves to coordinate. So that what you say to the algorithms is maximize my profit, okay? And they determine the strategy. And there's a really interesting study by Calvano and others from University of Bologna and from the EUI, who have shown for the first time by an actual experiment that algorithms learn to coordinate. I think it's fascinating. It's also, I think, quite scary for us as consumers. So what are the challenges here? One of the challenges with regard to unsupervised learning, where the algorithms by themselves learn to coordinate the prices. One of the challenges is whether or not this is an agreement that comes under our competition laws, because the definition of agreement does not capture mere interdependent conduct, which is sometimes called oligopolistic coordination or conscious parallelism. And such conduct occurs when firms independently set their trade terms while taking into account their competitors' probable reactions to their actions. So what can be done? I'm making, let me just make a few propositions and open the floor. First of all, maybe one way to get to these algorithms is through what we call facilitating practices. If they take action that goes beyond just setting the algorithm. For example, if I make my algorithm transparent to you, okay, and I don't need to do so, okay, but I'm doing it, and that makes coordination easier, that might be captured under the law. In Europe, we might capture it under concerted action, but again, there's always a problem of remedy. What exactly do we tell the algorithms not to do in such scenarios? So I'll stop here, but it's a fascinating topic.
Well, that is a fantastic start. Let's continue it. So Dr. Abrantes-Metz, I was wondering if you could give us a similar view into how big data and related concerns inform monopolization or Section 2 type concerns.
Sean, I would love to make one additional comment to the really interesting exposition collusion before I move on to my designated topic.
Please do.
So I've been working on a lot of these cases, and one of the questions is really, and I am the economist in the panel, not the lawyer, who actually is liable for any of these if the algorithm learns to collude by itself. And something else that I think is really critical to stress, at least in my point of view, is that if you think of the framework for perfect competition, which is many, many players, perfect information, everybody similar to each other, etc. In that context, full transparency is going to lead to efficiencies. And whether there is coordination, yes, everybody's going to have the same price, but that's exactly what perfect competition dictates. So it is still not agreed upon whether pricing algorithms do actually lead to they do lead to coordination typically, but whether that coordination is one per se legal and two necessarily anti-competitive. And one of the things that I personally look into is not just, this goes back to my background in collusion. When I try and detect abnormal prices, 20 years ago, I would tell you, well, prices that are too similar to each other are suspicious. Well, that's no longer enough, because this kind of algorithmic collusion will lead to very similar prices. The question then becomes, what happens to profit margins? If we're all pricing equally and low, that doesn't seem to be much of a problem. But if we're pricing equally and high, that does seem to be the problem, potentially a problem. So I would love the opportunity to talk so much more about collusion, but I am now going to talk about a little bit of these aspects of big data in monopolization cases. So I agree with everything that my fellow panelists have discussed to date. And so big data, just like with the example of collusion, it cannot be analyzed just by itself. It needs to be analyzed in the context and in the features of the market within which it operates. Just like collusion, we need to know, well, do we have 2 or 3 players in here, or do we have 20 of them? And in the context of big data and potential monopolization, it's the same thing happens. We need to understand what are the features of the market, what is very specific to the market that may or may not make us concerned about a particular incumbent with very large market share, or even just a monopolist, making use of big data to effectively block entry of a potential competitor. So I think that while many people have compared the issue of big data as a barrier to entry to Standard Oil from 100 years ago, how hard it was to enter into these industries, there's many important differences here. And one is that in big oil, entry costs are, in relative terms compared to a lot of the industries we're talking about today, extremely high. It is a whole lot easier in general to enter into the industries of social media and others. So I in general, while big data can provide an advantage to a large platform or an incumbent platform, I do not think that it must by itself create the presumption that it is allowing market power to be sustained, and it is foreclosing the ability of an entrant to enhance, to come in the market and successfully compete. Now, in the context of platforms, it is not, to a certain extent, very different from a more standard one-sided firm. It can be a little bit more complicated to analyze. So let me talk about platforms and monopolization. So what really is a platform? A platform can be defined in terms of its content or functionality. For example, we can have gaming platforms, we can have social dating platforms, we can have transactional platforms such as a trading exchange. There's many different types of platforms, A simple platform is a telephone company that aggregates and connects all callers to each other. So a platform can have one type of subscribers, such as the example of the telephone company, that a standard telephone company is going to have one type of subscribers, the callers, or it can have 2 or 3 or 5 or many other sides. For example, a trading platform connects buyers and sellers. So depending on how many sites we have connecting to each other, the analysis can be a little bit more complicated. And a platform that does have a lot of big data could potentially attempt to use that data, that advantage, not only to sustain monopoly in one particular side of its platform, but also to enhance monopoly on a different side of the platform, or even more complicated. If there's an incumbent, cases do exist where the incumbent runs 2 platforms that are separate but are related to each other. Could such an incumbent use big data on one of the platforms to then conduct what is known as monopoly leverage? So to gain monopoly in one market using the advantage of the data from the other. So the analysis gets more complicated potentially, but what really does the empirical evidence tell us about the evolution of big data in the context of platforms to date? And again, I don't want to generalize. This is all important to have in context on a case-by-case basis. It is highly market specific. But we do know that platforms face dynamic competition. There is disruptive innovation that provides opportunities for entry. And platforms know and do not feel necessarily secure in their leadership position, which is sometimes fragile. So they are afraid of being displaced, and often they have been displaced. We know BlackBerry and Windows in smartphone operating systems were displaced, AOL in messaging, Orkut in social networking, Yahoo in mass online media. So all of these are examples of platforms that were the leaders, and in many cases, the only player in the market, and were displaced. So if big data really represented a high barrier for an entrant in these markets, because the entrant could really not operate without access to that big data, how would we explain the rotation in leadership in these different markets? My view is that one cannot and should not plainly state that big data does necessarily provide a larger barrier of entry to a point that it effectively forecloses entry. In order for that to happen, it is possible and likely that other type of conduct may be ongoing. So a lot of these data are available and can be replicated with some effort and time, but are available out there, and potential entrants can collect it, can organize it. And that explains part of the rotation in leadership that I explained earlier in other markets. Also, some of these data can become obsolete fairly quickly. So its value is reduced quickly with the passage of time. So I think we must be very careful in making statements about generalizing big data and the ability that it must provide an incumbent company, a large incumbent, and that we must therefore be very worried that entrants are not going to be able to come in. Something very important, and again, goes back to the context of we have to have all of these together, analyze it specifically to the market at hand, is that while it is true that if you ignore anything else, big data does add a greater difficulty for the entrant to come in, because at least the entrant has to collect that big data in order to obtain what's known as the critical mass, the minimum size of the platform that is going to enable it to succeed in the marketplace. Some industries and some platforms are also characterized by what's known as strong network effects. And the literature, if you go check the literature in this topic, is a little bit confusing in respect to what's called strong or weak network effects. But let me just explain this. So what is a network effect? A network effect implies that the value of the network increases with the size of the network, so the number of subscribers. So that means that maybe a platform of 1,000 subscribers might be more valuable than if we break the big platform into 10 non-overlapping platforms of 100 subscribers each. If there is this synergetic value of a large platform, so that more people together in many different sizes generate this additional value that otherwise would not be present if we were to break the platform in non-overlapping platforms, then the strength of these network effects needs to be taken into account when we think about whether big data is enhancing these network effects, so that while at one hand, big data in the context of multi-sided platforms could raise the bar for an entrant to come in, on the other hand, it may be enabling a lot of synergetic value by the big platforms. So these kinds of arguments and efficiencies should be taken into account when running through the specifics of a case of this type. Thank you.
Well, thank you so much for that. This has complicated the question a lot and in an important way. So why don't we continue that? Professor Sokol, I was wondering if you could carry forward the conversation that we've kind of had so far into what it means for acquisitions, mergers, or other conduct that wouldn't fall under the broad categories we've already discussed.
Thank you, Sean. A lot of these comments really build on the kind of analysis that Romy mentioned, essentially, and with some tweaks regarding the law, the economic analysis is more or less the same, except with one big exception, a lot of it on the merger side, and specifically with regard to data-related mergers thus far, it's really been prospective rather than retrospective. So there's a lot more guesswork and uncertainty. But the same type of analysis is exactly what you heard with regards to the side of dominance. So so the questions, I'm sorry, by that I mean unilateral conduct, Section 2, but one could presumably also think about this as a FTC Section 5 case, or in some ways, there's sometimes overlap also Section 2, Section 5, even Section 1 sometimes. Welcome to the peculiarities of US antitrust law. For the same kind of conduct, framed ever so slightly, you get a different legal claim. But focusing specifically on mergers, what's interesting here is that we have essentially three kinds, broad types of mergers involving data. One where data is the input, one where data is the output, and one where data is the market itself. And we're going to look at the role of data differently in each of those kinds of situations. But in some cases, we're looking at data in terms of direct competitors or potential direct competitors. And so we get an additional area where we're thinking about whether or not this is nascent competition, so that on their own, the target firm would be able to compete with the firm that is acquiring it. So a merger that seemingly does not seem horizontal at all, but let's say in an adjacent market may in fact be a horizontal merger. So that adds additional difficulty. Then there's an issue of, well, what happens when they're adjacent markets? So it's not technically a vertical merger, although sometimes we have real vertical mergers with regards to data analytics. But what happens if it's in an adjacent market? It's definitely not horizontal, but it's not vertical, but we treat it as simply non-horizontal. And historically, we have viewed this with less suspicion than we have with regard to horizontal mergers. And so people always say, well, what's the empirical evidence for that? There's no empiricism. That's not quite right. With no offense to Romy, it's actually not from the economics literature, but it's actually from the information systems and the strategy literature, where we actually have a series of publications in the last few years looking precisely at these kinds of mergers, of adjacent merger markets. What do we know specifically about platform companies as a particular type of big data? But it doesn't have to be limited merely to platforms as such. We could think of big data without a platform. So for example, that would be, say, in a more vertical context, a big airplane manufacturer decides to buy one of its upstream suppliers that has unique data from sensors. And so the reason I mentioned unique data, because it goes to something Romy talked about, which is how easy is it to substitute data? So some 5 or 6 years ago, I thought, once the data is out there, you have so many different sources, and that's typically true for end consumer data. That tends to be less true under certain circumstances for, say, upstream industrial data, or in some cases, health data. And by health data, I don't mean the kind of consumer type data that is relatively easy to get. I'm thinking specifically about protected, say, HIPAA data. So it's a different kind of regulation. It's not the FTC regulating, rather it's HIPAA. And so all of these are going to come into the basic merger analysis. And the merger analysis will be guided by our merger guidelines. Note, unclear how long either the vertical or horizontal merger guidelines will continue to exist in their current form. Vertical, I think, will be scrapped before horizontal, but everything in the United States is now up for grabs. What that means going forward, I don't know. And frankly, I don't think anyone knows. But in a world where we just assume that it exists for now, because there are always deals in front of the agencies, we start with our merger guidelines to try to understand what to do. And frankly, we've seen many cases involving nascent acquisitions. So we simply apply data to this kind of framework that would help us with the nascent acquisition. Or it may be just a traditional horizontal merger. And we have all kinds of ways of working through how horizontal mergers work, or even a pure vertical merger, or even an adjacent market merger. So in a sense, nothing changes, except we're looking at data instead of looking at, let's say, software or lumber or breakfast cereals. And in that sense, it's not different. In another sense, it is different because we're looking not just at static effects, but we're also looking at dynamic effects. And that complicates things even more. So have we had merger challenges involving data? Yes. Have we had merger challenges involving big data? We're sitting on one right now in front of the FTC, and not quite sure what's going to happen there. What about mergers that have already happened? Well, it turns out the FTC has done a retrospective study, which has not yet been released, looking at the acquisition patterns of a handful of tech companies involving platform tech specifically. Presumably, acquisitions involving big data may be one of those issues that they've looked at, but we don't yet have that report. So again, we don't know. So I can give you the general contours. I can't give you anything specific that really gives definitive value, other than say we have seen mergers that involve big data, and they use a very traditional analytical framework that we've seen before for, the last 20 years in terms of the current, 10 plus years in terms of the current iteration of the merger guidelines. And really, I'd say when we started thinking about innovation seriously, that was probably 20 to 25 years ago. So we do have very expert people in the antitrust agencies who focus on these issues. And again, it's case by case analysis.
Yeah, the quickly and kind of, to my mind, obviously emerging theme is, yes, it's different, and yes, it's the same. It's the framework continues to apply, but, and then the but is the interesting part, because whereas the FTC has developed expertise in certain areas and then looking at certain mergers, the big question, I think, moving forward is going to be, well, what are the other unknowns that we have to deal with here? So what, if we're going to use the existing framework, and we can for now assume it, because what else are we going to assume? Well, then what else is it we need to fill in order for that framework to adequately fit these topics? So why don't we do this? We have a little over 15 minutes left. Maybe each of you could give us kind of your 5 or so minutes thoughts on, well, what are the big issues we need to address at this point? And you can also use the opportunity to respond to anything else that came up. Professor Gall, maybe we could start with you. So any thoughts generally, or any thoughts on, well, what's a big issue that needs to be addressed in order for us to continue to work with big data in a meaningful and tractable way?
Sure. I mean, there's so much to say here. Let me just throw out a few pointers. First of all, if I might respond to Romy on one point regarding disruptive displacement and rotation in leadership. I completely agree that we cannot generalize that big data creates market power, but at the same time, we do see that some of the firms are dominant over time. At the same time, I should say that it's not only data. The situation is not only based on data-based advantages, and sometimes people forget that. So if you look at Google, for example, it has advantages that have to do with immediate interest of consumers, or caching the web pages. Okay, these are things that are not necessarily immediately data related, but they create some of the market power in digital markets. What are some of the challenges beyond what we've talked about? Or what are some of the interesting issues that I think that students and others or researchers might want to think about? So some of them are, I think what other types or new types of conduct are, for example, challenged is monopolization. So a few weeks ago, I was part of an OECD panel that looked at the question of whether intentional limitations on data interoperability and portability constitute monopolization. I think that's an interesting and new question. Another one has to do with excessive data collection. This is especially important for Europe, but Germany has already found, the Supreme Court has found, that this might be a form of monopolization. What do we think about it? Limiting access to data which is otherwise publicly available, but it was collected for other purposes, like in the case of HiQ versus LinkedIn. All these are questions that have to do with data, and I think are fascinating to think through. Also, I think that some of the main challenges come from remedies. Okay, let's assume that we found that a firm has indeed abused its power or engaged in an illegal agreement. What then? What do we do then? And what we see is that at least some of the traditional remedies are not working for us. Think about Google. Think about the fact that it has already paid more than 8 billion euros in fines in the EU. Did this create a sufficient deterrent to future engagement in illegal conduct? I doubt it, and not only me, but many people doubt it. And simply policing conduct once incumbency advantages are significant may also do little to restore competition in markets, especially those prone to tipping. So I think it's interesting to think about some of the remedies that have been put forward in the past few years, which are a bit unique to digital markets. And let me name just a few. For example, the mandatory sharing of data inputs. Okay, so for example, a firm that has illegally obtained data or has illegally blocked access to data that others should have been granted access to might then need to share its data with other firms. This might be one scenario, there might be others. Of course, there are many limitations here. Okay, one thing that we haven't talked about in the data area is that private data actually clashes with privacy. So we actually have another set of considerations in the data realm that we don't necessarily have in other realms. And there are other limitations as well. I just want to name the remedies because I don't think there's time for more, but I want to put them forward. First, interoperability, for example. There's a lot of talk about whether or not we should force firm to interoperate the data, okay, to create maybe a better multi-homing and to allow users to move their data more easily. Of course, it comes with its own costs. Another remedy that might be interesting here is structural remedy that there's a lot of talk about, but again, the question is how do we do that and whether it's efficient. I doubt it, but there's talk about it. And lastly, something that I've written about with Nicolas Petit, which is the mandating sharing of algorithms. Don't share the data because it might be that the data is actually infringing your infringing privacy laws. You're infringing privacy laws if you share it. So share the learning, share the algorithm with a part of the algorithm that is based on illegally collected data. Okay, and that way creates restore competition in the market. So I'll stop here.
Thank you so much. Dr. Abrantes-Metz, did you have any reactions you wanted to share or kind of thoughts for what are important topics for the future in this area?
Sure. So very briefly with respect to the pricing algorithms, I think that while we're still not sure whether they make collusion, talking about per se illegal collusion, more or less likely, I also think that firms should have a better understanding of what they are or should be allowed to do with these algorithms and not. So I am in favor of some guidelines that set, you know, the tone for what agencies may be looking at as potentially suspicious in terms of inputs into an algorithm, pricing algorithm, etc. I think these uncertainties is just not beneficial. And so with that regards, I think this is, for me, one of the most important things to make it clear. As somebody who thinks about but for worlds all the time in the context of alleged conduct in my cases, something that I have thought very strongly and keep thinking about and analyzing is the issue that I mentioned earlier of what is the strength of these network effects? So think about the example I gave you of a platform, 1,000 subscribers, and it generates all of these synergies and value. Imagine that those synergies are really, really big. And if you had to break the platform into 10 platforms of 100 subscribers each, and they cannot communicate with each other, the value of the 10 platforms added up is lower than the overall value of the large platform. That is critical. It is critical to understand whether that's the case, whether the large platform is adding synergetic value that smaller platforms cannot add, whether it is the same, I would call that linear effects, or the large just so there's too on at least and platform is actually just providing less value than if you were dividing it all up into little platforms. Why is this important? Well, this is important for all aspects of understanding a but-for world, but for alleged conduct, for example, of monopolization, to understand whether should I expect, but for this alleged conduct, imagine some exclusionary practice, should I expect lots of competitors? Should I expect a few competitors? And that is obviously going to determine, but for prices, but for many things. So thinking about how to analyze the network effects, the strength of network effects from one side to the other and vice versa, how do you empirically test these things is, in my view, something that I have been conducting in my cases, but when necessary, but it's also something that I think academia may end up starting to think more heavily than it has over the last few years. This is also important for regulation. Now imagine there's a platform that generates this huge value, but at the same time it is also engaging in anti-competitive conduct. So what do you do about it? Are you just going to break it all apart and lose the synergetic value? If you're not, obviously on top of potential monetary relief, if you're not, then what's the solution? Are you going to grant access to competitors? For how long? There's all of these issues that do depend the strength of the network effects that I don't think are really being addressed right now the way it should. I would only just add, and not unrelated to all of these, the fact that some jurisdictions are starting to put forward possibilities of regulating multi-sided platforms as utilities, and essentially utilities. And just think about how different these things are potentially. Utilities typically a natural monopoly. There's decreasing costs. There's really no room for a competitor there who can efficiently operate. But it's not typically characterized by innovation. When I think about my electric grid, I'm not excited about the new products they put forward every year. I'm also not multi-homing on my electric grid. So there's so very many differences between the two. I worry about making too many comparisons and trying to cut the one-size-fits-all approach to regulation of multi-sided platforms.
That's many helpful thoughts. It's interesting, both of you so far have really identified remedies as a critical aspect of this, and maybe kind of the linchpin. Professor Sokol, I was wondering if you had any thoughts or other ideas on remedies or other topics for things that need to be dealt with to address big data and antitrust.
Remedies are important. So we're also assuming right now that the remedies are going to come from the courts primarily, at least in the United States. I think we may need to revisit that. Some of these remedies may come from new legislation. And the remedies being proposed right now are frankly rather draconian and would destroy value rather than create whatever the alleged anti-competitive concern is. And let's be clear, there's always pro and con to all of this. And in a rule of reason world, and again, it's not clear that at least one of the agencies really thinks highly of rule of reason, but in a rule of reason world, there are some negative effects, of course. But right now, some of the legislation looks rather draconian with regards to remedies. Some of it, I think, is also just not well thought through. So it could be either through potential rulemaking, which is now on the table for the first time, really effectively ever, because yes, it happened once in the FTC's history for antitrust, but then it was removed before it actually went into effect. So we're in a new world there. But let's actually think about two areas where I think people haven't really thought through rules carefully. So with regards to interoperability. So let's be clear, we do need some amount of interoperability. It's not easy to do from a technical matter, but let's follow the following thought experiment. So we make interoperability really, really easy. How do we deal with issues of liability? Because what we have just created now is the next Cambridge Analytica scandal by making it too easy to have interoperability. Don't think that people have really thought that through. Why? Because it makes for bad headlines to say, wow, we're going to take this very seriously. And, you've heard from both Romy and Michal exactly how difficult these issues are. So that's one part of it to think about, like specific to interoperability. But I think Michal also particularly raised the importance of privacy more broadly. And I think this is important because sometimes competition and privacy have parallel interests, but in other settings, they are definitely conflicting with one another. And when you think about remedies, you better think very carefully about that. What is the remedy that you want? So is it that you just stop the anti-competitive behavior? Or do we also address some of the privacy issues? And then there's privacy, and then there's sort of stuff that's dressed up as privacy. These are simply complicated issues. And I think that not enough, one of the reasons you're hearing all three of us care very much about remedies, it's very easy to say we need more, we need different, but then it's how do you implement? And implementation ultimately comes down to remedies. What's worked? What hasn't? So at least on the merger side, we have merger retrospectives that are always helpful in terms of guiding future behavior, because it turns out what we thought might have worked actually didn't work particularly effectively. Sometimes we didn't think that the remedy at the time was all that great, turned out to be much better than we anticipated. And so the question is, why is that? And that frankly requires lots of resources. Not to bring a case, to bring a case is relatively easy. I mean, resource intensive, but relatively easy. To actually bring a case that you can win and have an adequate and sufficient remedy, that's really hard. And actually, the caution that I have here is the Microsoft case, not a case involving big data, but really, I think in the last 50 plus years, the most important monopolization case we had. I think it was a good case. I think that the evidence was certainly there that Microsoft had undertaken anti-competitive conduct. No question from me on that. No matter who you ask, those on the left or those on the right, not a single person says, wow, those potential Microsoft remedies were great. And why? Because none of them were. And so the question is, now, what does that mean for policy? So if we can't articulate a workable remedy, do we even bring certain cases? Unclear. You might say, well, it would chill certain future behavior, but then we're left with a big mess in this particular case. And these are not easy policy questions. So I would simply say, when we get past the flame-throwing rhetoric that we have a lot of, and we have two types, those who say, let's destroy the system because we don't like it, and those that say, let's destroy the system by not doing anything, leading to more attacks. So I'd say that the flamethrowers of the left and the right. Once we get past that, we get to a reality for which remedies are really, really critical. And unless we really solve the remedies problems, and I say problems, it assumes a number of things. A, we have anti-competitive conduct. B, that we, if we have that conduct, that we can prove it in court. C, that if we have that conduct, we can prove it in court. Now we can actually have a workable remedy. That's where the big battles are going to be going forward. In reality, it's all about the implementation.
Well, it's interesting to me. Antitrust has been complicated for over 100 years. There's not a single case that hasn't been far more complicated than any layperson would have thought it would be at the start. And in a sense, this is nothing new. But the thing that this last hour has done, I think, really nicely is highlight where a lot of the really critical complexities are, and also to show who's working in this area. So we're all really fortunate to have you all doing research in this area. And I really value the time that you put aside to talk with me and us about this. Thank you so much for talking with us today. And I look forward to seeing the future work that all of you are doing in these areas. So thank you again. I really, really appreciate your time.